Conventional wisdom says American courts are being overwhelmed by civil litigation, especially tort litigation arising from personal injuries. This conventional wisdom is the premise for many of the arguments against litigation finance, which assert third-party investment in litigation must be banned because it will only exacerbate the problem of courts being overburdened by too many tort lawsuits. But what if this premise were false? The Wall Street Journal recently reported the number of tort lawsuits in state courts has fallen dramatically since 1993. Analyzing data from the National Center for State Courts, the journal found less than 2 out of every 1,000 Americans filed a tort lawsuit in 2015. In 1993, the rate of tort lawsuit was 5 times higher, as nearly 10 in 1,000 Americans filed such cases then. Other statistical data is in accord. The Bureau of Justice Statistics, a division of the Department of Justice, found the number of civil trials dropped by 47% between 1992 and 2001. Similarly, the median inflation-adjusted award in all tort cases dropped 56.3% between 1992 and 2001 to $28,000. There are several reasons for this precipitous decline in tort litigation. Since the 1990s, many states have been aggressive in enacting tort reform legislation. Such legislation takes a variety of forms, including, among other things, shortening limitation periods, placing caps on permissible awards for punitive damages and damages for pain and suffering. These reforms make it harder to win tort cases and therefore make such cases less attractive for lawyers to take on a contingency fee basis. In addition, the increasing cost of litigation may also be prohibitive for tort plaintiffs. The declining number of tort cases and the declining size of tort judgments make it clear there is currently no such thing as a crisis of excessive tort litigation. If anything, tort reform has resulted in an overcorrection in which the cost and benefits of tort litigation have been thrown out of balance. Increased access to litigation financing can restore the cost-benefit balance by making it easier for plaintiffs with meritorious claims to handle litigation expenses. And attorneys may be more willing to take meritorious cases on a contingency fee basis if they know litigation expenses will be covered. If you need help with litigation funding, call or email me today.